Among the legal ingredients to determine the very scope and jurisdiction of equality, we have to discuss certain leading cases. So, the first one is Usha Mehta, Government of Andhra Pradesh. In 2013, the Supreme Court expressed that the concept of equality enshrined in Article 14 of the Constitution is a positive concept if an illegality or irregularity has been committed in favor of an individual or a group of individuals. Others cannot invoke the jurisdiction of the High Court or of the Supreme Court and seek a direction that same irregularity or illegality be committed in their favor by the state or its agencies as it was declared in this leading case Usha Mehta versus Government of Andhra Pradesh in 2013 by the Supreme Court, and in the second important leading case RSIDI Corporation versus SS Cooperative Housing Society in 2013, again Supreme Court reiterated that Article 14 cannot be used to perpetuate any illegality as it does not envisage negative equality. It applies only when individuals' discrimination is meted out to equals as the doctrine of discrimination is based upon the evidence existence of an enforceable rights. And now we'll go to the third important leading case that relating to very doctrine of equality, and that is Commissioner of Police versus Meher Singh. In 2013, the Supreme Court expressed that the doctrine of equality would not be attracted where the benefit relief was conferred on the basis of illegality, fraud, or error. So also in another important leading case, that is Trivikram Burma versus Avinash Mohanty in 2011, the Supreme Court expressed that the complexity of a decision making process cannot be a defense when a grievance is made before a court by a citizen that his fundamental right of equality has been violated. And now we'll go to another important leading case, that is State of West Bengal versus Devashish Mukherjee in 2011. The Supreme Court expressed that it is a well settled fact that the guarantee of equality before law is a positive concept and cannot be enforced in a negative manner. And in this context, we'll analyze the last most important leading case, that is State of Madhya Pradesh versus Medha Patekar in 2011. Supreme Court expressed that as the right to equality under Article 14 of the Constitution is available against the state, it cannot be claimed against unaided private minority schools. So now we'll go to another legal ingredient which let down the very scope and jurisdiction of equality, and that is the very equals and unequals. So, in regards to that, we will discuss the very important leading case, St. Stephen's College versus University of Delhi, and the very judgment was delivered in 1992 by the Supreme Court, where it was pronounced that unequals are not only permitted to be treated unequally, but also they have to be so treated. And now we'll go to the second important leading case relating to that is another most important leading case, and that is Indra Sahani versus Union of India in 2000. The Supreme Court expressed that the creamy layer in the backward class is to be treated on par with the forward classes and is not entitled to benefits of reservation. If the creamy layer is not excluded, there will be discrimination and violation of Article 14 and Article 16, Clause 1 in as much as equals, forwards, and creamy layer of the backward classes cannot be treated unequally. Again, non exclusion of creamy layer will also be violative of Article 14 and Article 16 Clause 1, also Article 16 Clause 4, since on equals the creamy layer cannot be treated as equals, that is to say, equal to the rest of the backward class. And another important leading case relating to the very ingredients of equals and unequals is the leading case, that is Omkar Lal Bajaj versus Union of India, and it was decided in 2003 by the Supreme Court, and where it was pronounced the equal treatment to unequals is nothing but inequality. To pull both categories, tented and the rest, at par is wholly unjustified, arbitrary, unconstitutional, being violative of Article 14 of the Constitution, as it was decided by our Supreme Court in the important leading case Omkar Lal Bajaj versus Union of India in 2003. So now we'll go to another legal ingredients which help us to explain this very scope and jurisdiction of Article 14, and that is principles of natural justice. And in relating to that, we will discuss the very important leading case Manohar Manik Rao versus State of Maharashtra, which was decided by our Supreme Court in 2013. And here it was pronounced that hearing the parties' application of mind and recording of recent decision are the basic elements of natural justice. The adjudicatory process essentially has to be in consonance with the principles of natural justice, including the doctrine of Audi, alteram, parterm. And the second important leading case relating to principles of natural justice is P. Mohanandaram versus President ICAI in 2013. The Madras High Court's division bench expressed that a person cannot be allowed to raise the plea of violation of principle of natural justice who refuses to appear in spite of receipt of notice for appearance as it was decided in this leading case. P. Mohan Sundaram versus President of ICAI. And now we'll go to another important leading case, and that is Arun Yadav versus State of Jharkhand in 2012, and it was decided by the Jharkhand High Court, where it was expressed by the High Court that a non-speaking order is opposed to the principle of natural justice. And now we'll go to the last important leading case relating to principles of natural justice in explaining the very scope and jurisdiction of Article 14, that is Ayub Khan, Noor Khan Pathan versus State of Maharashtra. In 2013, the Supreme Court expressed that the cross examination is an integral part of the principles of natural justice. So now we'll go to the next most important ingredients in determining the very scope and jurisdiction of right to equality, and that is rule of law. So, in context rule of law, we will discuss two important leading cases, and one is State of Odisha versus Mamata Mohanty. In 2011, the Supreme Court expressed that an action of the state or its instrumentalities should not be fair, not only be fair, legitimate, and but should also be without any affection or aversion. It should neither be suggestive of discrimination nor even give an impression of bias, favoritism, and nepotism. And the same pronouncement of the Supreme Court in this 2011 leading case relating to State of Odisha versus Mamata Mohanty, it was again pronounced by our Supreme Court in the same year in 2011 in another important leading case, that is State of Maharashtra versus Sarangdhar Singh Shivadas Singh Chauhan. In 2011, the same decision was pronounced by the Supreme Court. And now we will go to another important legal ingredients which also exactly define and explain the very scope and jurisdiction of Article 14, which relates to right to equality, and that is reasonableness. And in context of that, we will discuss one important leading case, National Council for Teachers Education versus Shisham Shikha Pratishthan Sanstha in 2011 by our Supreme Court. And in that particular leading case, It was exactly explained the very idea of reasonableness. So, as it was expressed by the Supreme Court, an important consequence of the right to equality is the element of reasonableness. Classification which is unreasonable is open to challenge, and to this extent, the policy of legislation is open to judicial review. And as it was pronounced by our Supreme Court in this particular leading case, National Council for Teachers Education versus Sri Shyam Shikha Prakashan Sanstha in 2011, and in our upcoming video we'll discuss some other important legal ingredients which define the very scope and jurisdiction of Article 14, which relates to right to equality.